Thanks for joining, Kathy. We'll give it another minute to see if anybody else hops on. Um,
Sounds good.
Good, awesome. I will say too, as I always do, like if you have other just general questions, after this is done, we can answer those as well. We have learned, or I mean, I anticipated this, but these kind of new trainings that we've been doing have not taken the full hour, which they used to. So there's just a lot of time for questions afterward.
Okay.
So,
Hi, good morning.
hi, Andrea. Thanks for joining us.
Of course. Thanks for having
Hello.
me.
Yes. Okay, well, you guys are on time, so I'm not gonna waste your time by waiting for others. So we'll get going. So a lot of this is going to be just kind of redundant, and like there's really only one answer, one main answer when it comes to post-closing disputes. And this is when the case often is the case where um, property closes, transaction closes, and then one of the parties comes back to you and says, X happened. What do I do now? So, our role once a closing happens is minimal, zilch, basically, in terms of what we can offer. Um, and again, I'll also say all of my trainings, all of our trainings for deal defense, the majority of this is going to come from the WRA. And this is the case here as well. So I invite you guys, and I can show you where the legal hot tips are as well. There's a lot of information in our legal hot tips on the WRA website that is just fantastic. So according to the doctrine of the Dinger case, once a transaction has closed, the agent has no responsibility to assist the parties with the situation. So our authority to act on behalf of a party and provide limited legal services concludes when the agency agreement ends, which is at closing. So getting involved actually exposes our liability for perhaps the unauthorized practice of law. So it is very like cut and dry in terms of what we can offer to a client. And I know that we want to help. Obviously, we have been working with this client, all along. And so it feels counterintuitive to just have to cut that off once it closes. But really, it just opens up you to liability if we are trying to help in any way once there's a post-close issue. And getting involved after the closing may inadvertently lead the party to believe the agent is taking responsibility to help resolve the issue in a legal context. So it's kind of setting the stage for kind of some examples that we have. So, um, I just highlighted kind of the most common things that happen when there's a post-close issue. So the first one, and actually we dealt with this over the weekend, last week, Friday, I should say. So once a closing occurs, and this is regarding personal property that's left behind. So often we'll get a call, hey, we closed and the seller left X, Y, and Z behind, and that was not part of the inclusions in the offer to purchase. So once the closing occurs, the buyer cannot unilaterally decide to dispose of personal property remaining after closing. So this helps you guys have a conversation with a client, um, in that it often might be the response where, hey, we closed. seller left it behind, so it is yours now to do with whatever you want. So that is not the case, and we don't want to ever give that advice. Um, so again, we're going to have to get the parties in touch with one another, but um, the fact is the seller could owe damages to the buyer for leaving the property behind. And the buyer may wish to contact the seller and attempt to make the arrangements for them to pick up the property, of course, or the buyer may remove and store the property with the seller being responsible to pay any charges. And then we're going to see this a lot. This blanket statement, these possibilities can be discussed with the buyer's attorney. The buyer would be well advised to seek legal advice on what to do with the personal property to avoid issues. So I think what the takeaway that I want you guys to have is that buyer cannot just dispose of it. We do need to make sure that they are keeping the items and making attempts to get in touch with the seller, but they can't just like dispose of it. And it doesn't just belong to them either. That comes up a lot. Tenant occupancy. So, and this is, this is information that you should be knowing when you're writing an offer with a buyer who is making an offer on a property that has a tenant. So, where we might come up with a post-close dispute around this is if the new buyer was not aware of this. So, in the event there's a tenant occupying a property, Wisconsin statutes state that a buyer takes title subject to the tenant rights. The sale of a property does not terminate a lease or rental agreement. So if a buyer comes in and attempts to end a lease early because they're quote unquote the new owner, they are not allowed to do that. So tenant leases supersede a closing. So if a tenant is in a lease for another 4 months after closing, then the new owner has to honor that lease. So again, this is information that a buyer should have, obviously, before making an offer. But it has been the case where they did not know. So discovery of issues, these are kind of similar to one another, but so discovery of issues, a new owner has evidence that the seller had knowledge. So um, in this case, it was a buyer who moved in, and the seller had left them like a tips sheet, like an FAQ about the house. And, in doing so, thought that obviously they were trying to help them, giving them some, like, this is what we do with the house in this area, etc. Again, just kind of like a frequently asked questions or like a tips around the maintenance of the home. And they had discovered the seller had indicated we get tree roots a lot, so we have Roto-Rooter come out like already scheduled ahead of time to come out and clear roots in our sewer, and that's on a regular schedule. And they had not made any disclosure about that on the real estate condition report. They made no mention of this prior to the closing. Excuse me. So sorry. So buyer moves in, they see this and they're like, wait a minute, so there's a tree root problem? Um, and obviously have more questions about it. So again, if somebody comes to you with this, so buyers should be advised that the issue would need to be resolved by the parties themselves, or with the assistance of legal counsel. And we're going to see this statement a lot. So to hold the seller liable, a buyer will generally need to demonstrate that the seller knew there were pre-existing problems or defects which he or she concealed or failed to disclose. So in this case, it's going to be pretty easily demonstrated that the seller did have knowledge because they wrote it right in a note. Um, in this case, it's always advised too that a buyer or a client's first line of offense doesn't necessarily have to be an attorney. Like they can try and work an issue out with the client themselves, with the other party to the transaction themselves. So, we can always communicate that to a buyer or a new owner or whomever might be trying to reach out. Um, you know, we encourage you to work this out with the parties ahead of time. If not, then you would need to be pointed to an attorney. So, um, and the third bullet point here is that the buyer may enlist the help of appropriate contractors to assist in establishing proof that a seller had knowledge. So the buyer may ask a repairman to document what occurred in anticipation of possible action regarding the issue. So that is a very important thing to note as well, and something that you could communicate to a buyer, um, new owner, that, as you're trying to get this figured out, um, I would just say you should make as detailed notes as possible about who you had in, about what their opinion was about the situation, etc. So if they do need to talk to an attorney, if they do need to seek legal counsel, then they will be prepared with records.
Steph, can I ask a question?
Yes, Bridget.
I have had a lot more issues with this in the last year where people are getting a little like lawyer happy or like like sue happy. I don't know what the term is. And I'm just wondering any advice for agents like to get ahead of it because I'm wondering if I should be kind of having a conversation before closing, like, hey, okay, so closing's coming up. Because it's like an awkward conversation. Like, you don't want to like be like, hey, so by the way, if like shit hits the fan in a week, I'm out. Don't call me. I can't help you. You're probably gonna need to spend thousands on an attorney. Like I just
Yeah.
but then when they do contact you after closing, it is awkward. And I'm just wondering like what people are doing.
Yeah, I think it's getting a script down, and one of my last bullet points here is gonna be around getting the other party's contact information. Because obviously we get that question a lot, right? Like, hey, can you get me the former seller's contact information? And that's always a very awkward thing to navigate. So I think it's just like getting the script down in terms of, you know, I can't give you legal advice. I am always happy to reach out to the other broker to find out if I can get permission to share the other party's contact information. Confidentiality does hold true after a closing, so I cannot give it out to you unless I get permission. So you can kind of just like relieve yourself of that. You cannot give it out without permission. So, and then another thing I'm always saying too is I can help assist. If you do end up contacting an attorney, I can assist in getting any paperwork that they may require. And like, please let me know how I can be a resource for that. But unfortunately, another bullet point that we like to make too is we always encourage parties to try and work that out themselves. Um, and if not, then you'll need to talk to an attorney. Is it something to bring up prior to closing? It possibly could be. Um, And how do you do that in like a tactful way? Because I agree with you that it's like you don't even want to like kind of plant the seed that there is going to be something. But it all could be like maybe a disclaimer in our contract to close processes. Like we've got kind of our templated emails that we're sending out. Um, and maybe it's a part of that. These are all good questions in terms of just like how to get ahead of it. But I do think too, with our desire to be helpful, that it is still, you want to be somebody who that they can call upon because like a lot of it is just venting, right? So, I've had people call it and just like, I know you can't do anything, but XYZ happened. So I think it's just like getting that script down. I can help you get any resources you might need to help aid in, um, a potential, I don't want to even say lawsuit, but like a potential inquiry with an attorney. Um, and I hope that you can work it out with the other party themselves directly. Um, and let me know how I can assist. So that was a long-winded thing, but I wish I had a better answer, something more concrete. But and I'm sorry to hear that you've got more litigious peeps. So
I know, I don't know. Even some that had inspections, so what can you
yeah,
do?
yeah. Um, yeah, there's some funny things. Actually, I think it's in the next example. But okay. So I think, oh, and then also to this, Bridget, like I think being able to communicate, you know, document your journey with this in terms of like who you've hired, what their opinion is, when they came out, um, I think that is also helpful reminders for a client. So, um, discovered defects after closing. So, this one, excuse me, um, this one was a case where, um, a I believe it was a lake property. There had a home inspection. Nothing was revealed about the foundation. But then there was like a major rainstorm after the after closing, and there was like water pouring in um, on two of the walls. So again, this line was just like all over the WRA. So again, buyers will generally need to demonstrate that a seller knew there were pre-existing problems or defects, which he or she concealed or failed to disclose. Again, buyers may enlist the help of contractors to assist in establishing this proof. Where this one went, though, this line of questioning from this particular agent was that it was expressed that the buyer might want to go after their home inspector. So, and again, this is nothing that I think you guys should be um, recommending or like bringing up, you know. That's like that's definitely overstepping in terms of like, oh, you could go and see what liability your home inspector might have. Like we should not be saying that. But just it's just helpful to know that a claim regarding the services of the home inspector might be made. And to hold the home inspector liable, the buyers would need to show the home inspector in some manner failed to properly inspect or report the observed condition of the property. Of course, again, a buyer should consult with an attorney about this, but it's also helpful for you guys to know that the statutes provide a 2-year statute of limitations for claims against home inspectors. So just like us, we are subject to a 2-year statute of limitations. Um, which it used to be 7 years, you guys, so it's great. It's down to 2 years. But it's just good information for you guys to have in terms of um, home inspectors and what could be brought against them. And then I think it's also just, this happens so much where it's just like you get into a home and, um, you know, more so with like mechanicals, like a mechanicals just suddenly fail, I think there's kind of like just this unspoken like rule that it seems like water heaters always go out like within a week after a closing sometimes. So where I'm going with this is like in some situations there are pre-existing problems, but other times there are just unique sets of circumstances that result in new issues in a property. So it may not even be something that happened prior to the person. It may not be an issue that a seller did or did not know about. It could be just a brand new issue with the house. So that's just something to keep in mind too when we're navigating these things. Again, kind of the same with like things like a home, like a water heater. Like, you could coach your buyer. I hate to use the word coach, but like kind of talk them through and you like kind of just being a support in that I'm really sorry that happened. And sometimes this just happens. And if you need me to try and reach out and get the contact information from the other party, I can try, but just kind of re-reminding people that shit just happens, excuse my language. So, um, actually, I want to go back to this one too, because yeah, this was the same example where, this was interesting and it's the same advice, but like a, this buyer had a home inspection. And I just think this is crazy. And might like speak to kind of what Bridget's experiencing with just people who are kind of crazy. They had a second home inspection after the property closed. And apparently that home inspector found a whole bunch of things that this is a different example, but they found a whole bunch of things that the first home inspector did not find. So the buyer, new owner, communicated to their broker they wanted to go after the seller for things that were discovered um, by the new home inspector. So those are kind of things again that you just like would not anticipate, same rules apply. If you feel that there was something that the seller knew about, you need to demonstrate that it was concealed or failed to disclose. So, um, and then again, too, that might be a situation where that buyer might want to talk to their first home inspector. Again, not for anything that we can talk to them about, but just like a possible scenario that might be outlined by their attorney. So, giving out contact information. So again, confidentiality extends past closing. So the broker may communicate with the clients and obtain permission to share the seller's contact information with the other party to the transaction. But again, the contact information cannot be shared without the consent of the other party. So to relieve yourself of this, again, point back to the duties that we owe to all parties, and confidentiality is one of them. And that's stated right into our disclosures. So, um, potential broker liability in a post-close dispute. So, kind of the things, again, not anything that we would be trying to explore, but just want to make you guys aware of like so many times when there is a post-closing dispute and it does get to a litigious situation where maybe a new owner is a bringing a lawsuit against the former owner. What we often see is the listing brokerage will get called into the lawsuit as a third party um, for things like this, what we're about to go through. So misrepresentation, and oftentimes buyers, attorneys will purposely go for the listing broker because we had the information right when we were marketing it. So misrepresentation, including concealment and the failure to disclose where this is required. So misrepresentation would be involved if broker had stated incorrectly that a particular part of the property was in good condition. Liability for misrepresentation might be founded on fraud that was intentional, negligence, or strict responsibility. I feel like negligence is where we get into most trouble, as it relates to a listing broker getting involved or being held liable. Um, Mostly just, again, it wasn't like intentional, just like didn't understand what was being said or communicated, or just failing to communicate something altogether. So failure to meet a licensing standard might come into play, for example. So if the problem could have been detected by a reasonably competent and diligent investigation and it was not. Volunteering to do something, such as having an expert check the septic system, and not doing it properly could also give rise to liability for property conditions. So this one, I had a hard time kind of swallowing, just in the sense that, obviously we are making recommendations for contractors all of the time. Definitely do not volunteer for a contractor to look at a component in a, after closing. But I think this just goes back to the three recommendation rule where, if we're giving out one name, we should be giving out three names. So I know that's not practice necessarily, but kind of just something to keep always in the back of your head. So, um, the consequences. I actually had to go through this a couple weeks ago, in one of our last deal defenses. So just kind of, again, reminders that licensees cannot provide advice or opinions concerning the legal rights or obligations of a party, and we should not be giving anybody legal advice at any point in a transaction. The code of ethics violation, if, this isn't just state statutes, it's also code of ethics violation, that says we cannot engage in activities that constitute the unauthorized practice of law. And again, always recommend that legal counsel be obtained. And if an agent violates the regulation, they could face a fine, a license suspension, or even potentially lose our license permanently. So it's a big deal. And a party to the transaction could sue the agent for damages related to the unauthorized practice of law, and a firm could terminate an agent's association with the firm, of course. The WRA legal hotline, the legal hot tips. I actually do want to show you guys. So I have this. So I don't even have the WRA.org bookmarked. I have WRA.org /legal/hot tips bookmarked. So in case you guys are not aware of the legal hot tips library category, you can either just like with the search bar up here to start typing something in, and then, or you can just choose a category. So post-closing disputes. So all of this, most of this I got from these examples. So just I want you guys to have an understanding and awareness that this is there. Because oftentimes if there's a question that we can't answer, I'm coming to this. So it's not information that others cannot access. I just want you guys to have an understanding of that. Like, this is accessible to all of us as agents. So, okay. Any other comments or questions, either around this specifically or anything else in general? Okay, hope this is helpful. I'm gonna let you guys know before we sign off what the next topic is. So give me just 1 second. Okay, so next week is advertising rules around social media and more. So that should be a good one. They're all good. All right.
Thank you.
Thank you guys.